The International Association of Procedural Law is fully aware that we all feel the need to keep connected and that we want dynamic and challenging exchange of thoughts. Last September, we had an excellent experience with the first webinar under the provocative title of Remodeling Civil Justice in Challenging Times, where Frédéric Ferrand dialogued with Teresa Arruda Alvim and Alan Uzelach on the impact of the pandemic on civil justice systems. For this second webinar, we've opted to put the focus on a most extraordinary development, the new European Rules of Civil Procedure. As our audience will probably know, the European Law Institute and UNIDROIT have recently approved a set of 245 model rules under the label of European Rules of Civil Procedures. The rules are the result of 7 years of hard work, involving 10 different working groups composed of more than 40 outstanding scholars and practitioners. The European rules are not, of course, an official code endorsed by the European Union. They are rather the result of a spontaneous initiative of the ELI and UNIDROIT wanting to work together. They back on a previous well-known experience which had led to the approval in 2004 of the ALI UNIDROIT Principles of Transnational Civil Procedure. But the intention here has been that of going beyond, from principles to more detailed rules, which cover all aspects of civil procedure. General principles and structure of proceedings, parties, case management, service and notice of proceedings, access to information and evidence, development of proceedings from their commencement until a final hearing, judgments, including their effects, means of review and appeal, provisional and protective measures, collective redress, and costs and funding. The endeavor, as you can imagine, was enormous, but so have been the achievements. Creating the rules has been a challenging experience. Even if limiting the work to the European framework rendered some tasks easier, it was necessary to put together different legal traditions on crucial aspects of civil justice and civil procedure, and try to follow the best rule or best practice approach when defining provisions. We cannot make an analysis rule by rule now, but we consider it basic for a global association, as is ours, to devote some time and space to the reflection on the impact of the rules, not only from an academic point of view, but also from a practical perspective. Therefore, the second part of the title of this webinar: do we have a new actor in the field of comparative procedural law, and more specifically in the field of procedural harmonization? Numerous questions arise, and we are pleased to welcome two prestigious colleagues and friends who immediately accepted to take part as speakers in this webinar. One comes from inside of the project and has been indeed one of the project's clearest driving forces. That's Professor Rolf Stürner. The other was not involved at all, and her view from the outside will be certainly most useful, especially bearing in mind that she gathers both an American and an Asian perspective. That's Professor Margaret. What could I say about Professor Stürner? I think he doesn't need any presentation, and he's one of the most renowned proceduralists today. He's currently an emeritus professor of law at the University of Freiburg, where he spent most of his academic career. He has also the valuable experience of having acted as a judge. He has devoted a significant part of his work to comparative procedural law. It's a real privilege for us to count with him today. The same applies to our other speaker, Professor Margaret. She has also shown the greatest generosity towards the association in accepting to be with us today. Currently professor of law at Northeastern University in Boston, she's also very active in the field of comparative law, where she offers the added value of serving as a bridge between the common law and the Asian tradition. We would like this webinar to be dynamic, lively, and spontaneous. We do not want our speakers to make a very detailed and structured presentation, but rather to answer questions, react to the statements of each other, and at the end of the seminar, to a few questions addressed by the audience. Using the chat, you can write and send remarks and or questions. We will keep some time before the end of the webinar in order to give our speakers the opportunity to answer some of your questions and to react to some statements. We have at most 1 hour and 15-30 minutes time to go through our challenging topic. So we should not waste time. I shall direct the first question to Rolf, to Professor Stürner. This first round of questions would allow us to gather kind of first impressions. So Rolf, Professor Stürner, you have been directly involved in the project from a very privileged position, since you were also a member of the ALI UNIDROIT project on the principles of transnational civil procedure. Apart from the obvious differences in scope, what are the main differences you see among both? I'm also curious to know if it was easier to reach consensus within European experts than during the discussions between experts coming from all over the world, as was the case with the principles of transnational civil litigation.
Yes, Fernando, thank you for your friendly introduction and for your question. And if you permit, I will begin with the second part of your question first, that addresses a chance for consensus on a global basis and a European basis. The ALI UNIDROIT principles of transnational civil procedure were designed to contribute to worldwide harmonization of civil procedure and to bridge the gap, especially between the Anglo-American and the continental European procedural culture and their worldwide respective progenies, originally dividing the procedural world in two different parts. It was the English Wolf reforms that improved decisively the chance for compromise acceptable for both procedural traditions. The modern English civil procedure abandoned nearly completely the jury trial in civil cases and corresponding law of evidence with sophisticated admissibility rules. At the same time, the reform has changed the purpose of the pretrial discovery stage. This flexible new structure brought English civil procedure closer to the continental procedural model. In many, not in all points, the compromise reached by these principles were based on essential aspects of this modern development in the motherland of the common law legal family. For me, as one of the two reporters of UNIDROIT, it was really surprising that the members of ALI accepted unanimously these principles despite a lot of remarkable concessions in favor of modern English development and continental procedural substance. The vanishing jury trial in the US dampens the strength of the traditional American position in the field of international harmonization, especially in commercial cases. So US American lawyers that still dominate CLI were aware of the fact that in the field of arbitration, where lawyers are mostly arbitrators, the traditional law of evidence has already lost significance, and that the role of arbitrators is already much more active than the average role practiced by the majority of our American court judges. This contributed a lot to the readiness for compromises. Additionally, the development of common procedural fundamental rights within the Western civilization influenced and formed both procedural models and was another important source of approximation. It is, however, remarkable that at present in the field of procedural law, differences between the US and England became more substantial than differences between modern England and the other European states. It is in the end the still existing and in part overestimated or really glorified American procedural exceptionalism that makes mutual understanding on a global basis more difficult than within Europe, including non-member states and common law states like now England. Now, some short words on the first part of your question regarding the implementation of the ALI UNITRA principles by the European model rules. There are some examples where the European rules exactly and faithfully implemented the principles without remarkable modifications or additional original input. In other cases, European rules developed some innovative mechanisms or concretized very general principles, always within the frame given, however, putting emphasis on specific European developments. Some examples for innovative and simple implementation I will give. The set of rules of the ALI UNITRA principles contains principles in the strict sense addressing indispensable fundamentals of civil justice and other general provisions providing a properly transparent and clear blueprint for well-functioning civil proceedings. The structure of the presentation of these principles is pragmatic and not oriented to clear differentiation between fundamentals and more technical details. It is interesting to see that the canon of the fundamentals in the European rules is much broader than in the ALI UNITRA principles. Following the spirit of the time, they put much emphasis on the principles of cooperation between parties and court and among parties, including settlement endeavors and the principle of proportionality, of the dispute resolution process regarding costs and resources. The in part serious debate about the weight of these somewhat innovative fundamental principles came to the result that it was necessary to keep balance between the traditional canon of fundamentals and the innovative newcomers, putting them into the interpretative frame of the traditional fundamental principles and rights in order to avoid a not intended supremacy of the new principles. A description of the relation between ALI UNITRA principles and the European rules should at least very short and point address the fact that the drafters of the European rules felt free, on the one hand, to implement some parts of the ALI UNITRA principles very intensively, according to the state of progressing European procedural convergence, and on the other hand, to add parts not already addressed by the ALI UNITRA principles, taking account of then lacking any good prospect of harmonizing developments. Examples for intensified implementation by the European rules are the part on evidence and especially on access to evidence, and the part on provisional measures. An example for innovative supplementation is the part on collective proceedings, upon serious discussions added to the original conception due to the fact that the clear majority of all national legislators and in the meanwhile even the European Union took steps to resolve the problems of mass harms. The draft of this part of the European model rules gained already the attention of national legislators preparing reforms. Here I want to stop.
No, thanks so much for this. I think it was a huge amount of inside information for outsiders, and I think you just gave the information we wanted to hear. Now let's turn to Margaret. You are a more neutral observer, but you're also a comparatist. Mm-hmm. what would be the first impression you gather from the European rules?
Yes.
Are they understandable from an American or even a global perspective? Would you even say they're well balanced? So, first impression from
Right.
you.
Yeah, well, thank you so much for this webinar. I think it's an important topic. And I just want to emphasize that these are really my initial impressions and that there are many, many other experts here, and I welcome their thoughts and their conversation. So from reading the rules, I think that in many ways, these rules are reflective of the European tradition, right? And really also reflective of the careful study of the best practices of the different European nations. These model rules as a whole are more comprehensive and detailed than either American or I would say Chinese civil procedure rules. My area looks at China, and so I'm not going to speak about Asia as a whole, but I would primarily do my comparison between American and Chinese civil procedure. But I do notice 4 kind of general trends that I like to mention that I find of interest. And the first is that, yes, these rules do reflect European tradition in the sense of supporting and continuing the idea of judicial supervision of the cases. But, and I think it's also from my conversation with Professor Stürner, is that it also reflects a very active collaboration and cooperation between judges and parties. In other words, when I first read it, I found that these rules gave more autonomy to parties than I would have expected. So, for example, if you look at Rule 24 and 23, and actually Rule 26, it specifically says that the scope of the dispute is going to be determined by the claims and that the court must decide early on only on the relief claims. So I gather it's kind of limiting the judicial authority to shape claims, and that courts must not consider facts not introduced by the parties, and that courts must determine the correct basis for its decision. Although it does recognize, however, in all these rules, the right of parties to dispose of their claims. They may agree on the legal basis of the claim or on specific issues of the claim, and that agreement will be binding on the courts. And so, again, I mean, this is the kind of careful balancing between the role of the courts and the parties that I didn't anticipate in the European rules. The other really interesting is how forward-looking these rules are. They incorporate really electronic methods of service and electronic access to evidence and the taking of evidence. The Chinese rules also have provisions for that, but the US, I have to admit, are still far behind. The Federal Rule 4, I think you can read it to permit electronic service in international context, but it's not at this point recognized in the domestic context. But I agree, again, I think that's going to be changed very soon, since with COVID, I know that discovery has been taken online, as well as hearing, taking of evidence has also been done online as well. So I think that we probably will see some revisions in these rules. So, but these rules are very forward looking and anticipating that technology is going to have to be incorporated as part of civil litigation. So the third thing that I thought was really also interesting is how the rules really incorporate a thematic emphasis. So the proportionality principles are incorporated throughout, from the beginning of the case to access to information to ultimately the costs and expenses and how the case is going to be litigated. And those proportionality principles contained in Rules 5 and 8 really permeates throughout the federal rules. I don't know Rick Marcus, I think, signed on, and I hope he could kind of add his thoughts about how difficult would it be for our federal rules to totally rehaul so that to incorporate some of these thematic emphasis throughout the rules. But it certainly makes, and maybe it's because the model rules were just recently discussed, but it certainly makes these rules much more cohesive rather than disjointed. And then finally, and this may be a little controversial, I don't know, but I try to go back and count, but the rules, the European rules seems to mandate rather than encourage more proper conduct. And I think it really is reflective of the importance, perhaps, of the role of the courts in mandating proper conduct, whereas in America, it may be the American Bar Association, is the professional associations that mandate proper conduct. But here in the rules, you have lawyers must inform parties about ADR. I know that we don't have that in the federal rules in terms of must inform parties, but I know that in state courts, there are certain docket sheets that before you file cases, you have to indicate whether or not you've discussed alternative dispute resolution with the parties, but it's less of a clear mandate. Here you also have judges must facilitate rule settlement. I went back to look at Rule 16, and it seems to Rick's already got comments. Rick, okay, I hope you'll jump in. But Rule 16 says that courts may, have a pretrial meeting to discuss settlement. Federal Rule 1 says that these rules should be construed and administered to secure just, speedy, but it should be rather than must. So again, I thought that these were really very interesting, very kind of perhaps both reflective of the European tradition and at the moment of time when these rules were discussed. But those are three thoughts. I have more, but we could move on.
Maybe you can develop them in the further discussion, Margaret. Many thanks. Well, I mean, I know, and I'm very thankful, and we made you study the rules.
Yes, you made me read.
You to the webinar. Maybe you had other plans over Christmas, but we gave you something to read. And at least we are happy you enjoyed reading the rules and getting in contact with them. I don't know, Rolf, if you've got any reaction to what Margaret said, or otherwise.
I want to make only a very short remark regarding the must.
Okay, I knew that much.
I expected you would.
That the rules make also clear, and at least the comments, that the must is only a form of information. The parties are in principle free to say, well, we could make a formal attempt, but we won't attempt. Yes. So this was discussed seriously, this must, and the degree to which the court has to further settlement endeavors. I myself would have been a bit more reluctant, but it's a trend in Europe, a very strong trend, to encourage parties to try to come to a settlement. I think one shouldn't exaggerate, and times may change. There are times where settlement is considered the best solution of disputes, and there are other times where there is a balance between judgments and settlements. So in the end, the rules are open to both forms of cohabitation of settlement.
But I think it is interesting the other day when we were talking about it, that you said these rules were very careful trying to balance between the role of courts and parties. And so
Yes. If I may add, probably some judges need to be reminded of their duties or what or about what is expected from them. But let's go back to Rolf. I would ask you openly, Rolf, what are the strengths of the model underlying the European rules? Do you think, in addition, that the so-called acquis communautaire has functioned as a valuable basis for drafting the rules?
As first, some words on the strong point of the European rules. In my eyes, it is a dialogical character of the model rules. The principles mention the parties' duty to cooperate within the context of prompt tradition of justice only, and they complement this duty by the general duty to act in good faith and by their responsibility shared with the court to promote a fair and efficient, reasonable, speedy resolution of the proceeding. The European rules seem to go much more far, establishing an overarching principle of cooperation binding court and parties, and including manifold duties like the duty of the court to active, efficient, and continuous court management and steady monitoring, already mentioned by Margaret, and the duties of the parties to endeavor to achieve reasonable and appropriate settlement, already mentioned by Margaret, and to contribute to proper case management. That's important. The parties have to contribute to proper case management too, to present facts and evidence, and so on. The comments, however, make it clear that the European rules neither follow the sporting theory of justice that puts strong emphasis on the parties' aim to be the winner of a battle for their rights as a promoter of proceedings, nor do they try to realize the idea of a cooperating procedural working group consisting of judges and parties and their lawyers. Both rules of conduct with corresponding duties and competition between the parties in managing their mutual risks to convince the court of all necessary factual, evidential, and legal aspects of their cases are to be accepted as an inescapable element of procedure. Cooperation includes the court's duty to give hints and feedback and to ask for amendment if a party's case is defective, and it must not draw negative inferences without previous monitoring. The European rules tend to realize the conception of a dialogue between court and parties, where court and parties act on the same level as long as the parties and their lawyers act fairly and in good faith. They are the first set of procedural rules that clearly curtails the court's power to evaluate a party's defective case negatively without preceding notice. A step towards transparent decision-making, not expressly proposed in the ALI Unitra principle. According to this procedural model, judges must enable parties to respond in time to the court's preliminary point of view on the party's case, no longer sitting like a sphinx and rendering a judgment without real exchange of arguments with the parties. The phase of administration of justice in civil cases should not be authoritarian, but visibly try to be open to better arguments when the citizens of a free society meet the representatives of state power in search of their rights. Especially worth to be mentioned are two consequences of this dialogical model: the determination of domestic and foreign law by the court, and the flexibility of the rules to fit for all kinds of cases as a consequence of a mandatory dialogical case management of the court. So there are no preformed tracks dividing cases in special kinds. Now, to the second part, some remarks on this difficult question of the significance of the acquis communautaire of the European Union, which is read like a Bible by many European jurists, and in parts there may be a conflict between generations. The older generation is more feels more liberal against the European acquis than the younger generation. It is clear the directives and regulations of the European Union, as well as the case law of the Court of Justice, were always taken into consideration by the drafters of the European rules. Now, not all European states are member states of the European Union, but nearly all are member states of UNIDROIT. The European rules, however, realize different forms of taking account of the European acquis depending on the special circumstances. Insofar as regulations like the regulation on jurisdiction and enforcement have a long and successful history, with many steps for improvement, the drafters felt no necessity for an additional other set of rules because non-EU member states could take such regulations as a kind of European model law to be adapted by their legislators to their national necessities, and so may do the EU member states adapting their national venue rules to the European Union regulation on international jurisdiction. Consequently, the European rules do not contain a part on jurisdiction, recognition, and enforcement. In other fields like service and due notice of proceedings, or lease pendants and related actions, the drafters were not fully convinced, in part not fully convinced, of the solution reached by the European legislation and preferred a set of model rules overtaking parts of European legislation and in part drafting differing rules. Where the drafters found European legislation in general satisfying, like in case of transnational evidence taking, the drafters inserted into the European rules some few individual rules with solutions considered as desirable improvements by the drafters. In the end, the European model rules respect mostly the legislative European acquis and also the courts of justice and the European Court of Human Rights case law. However, the European acquis is subject of steady changes, reforms, and revisions, and there is no good reason why the model rules should not make proposals for such necessary changes, reforms, and revisions. For example, the European rules did not overtake the Courts of Justice conception of res judicata and claim and issue preclusion as developed for cross-border cases under the regime of the Brussels Regulation on Jurisdiction and Enforcement. This conception was considered to be far too broad and may create unforeseeable and surprising results for the parties by extending effects of defective decisions and their reasoning, be they caused by parties themselves or by the deciding court, on a very broad scale to all follow-up proceedings between the same parties all over Europe. The rules did also not follow the Courts of Justice trend towards forms of mandatory fact-finding ex officio in cases where mandatory European law governs the case to be decided, particularly in consumer cases. Instead, also in case of applicable mandatory law, the rules prepare party disposition of facts and evidence combined with the court's duty to give feedback to the parties that mandatory law may apply and that the party who thinks to be favored by such legal rules may amend its factual and evidential contentions or runs the risk of losing its case in part or completely. There should be no duty of a party to be the winner in the interest of realization of mandatory law. The drafters of the European rules clearly refused any approximation towards inquisitorial proceedings on the marriage. This was seriously discussed, but in the end, this was a solution, and I myself, I am convinced that it was correct to be reluctant with to introduce inquisitorial elements insofar as disputes on the marriage were affected.
Mm-hmm, mm-hmm, mm-hmm.
Thanks, Professor Stürner. Mm-hmm. Well, the same I asked Professor Stürner about the strengths. Now I'm asking Margaret, what are the weaknesses you observe? The more difficult question, the more compromised question, and but also the other way around. What would you say? What would you see as a specific added value? Is there something rules you would envy or maybe feel jealous of?
Yeah. Yes, there are many items to be envious of, but I think I just want to mention three, and then I do have two issues that I wanted to get clarification about the rules, because it may just be my misunderstanding of them. But in terms of items to emulate, I thought, one, the pre-litigation obligations. I mean, it's terrific. That is that Rules 9 and Rules 51 really encourage parties to provide each other with information about contested or admitted fact during the pre-commencement phase. And again, maybe I'm misunderstanding how that is supposed to operate. But that certainly would be wonderful for the US, actually, to have something like that, considering that without pleadings, later Supreme Court's holdings on pleadings on Iqbal and Tremblay cases, where we now have to have much more specific pleadings that will meet a plausibility standard. And certainly it will be terrific if, in fact, in order to meet that, if we're going to have a heightened requirement for pleadings, that there would be some obligations for parties to provide the information so that plaintiffs could appropriately plead. Again, in the US, I think there are some subject-specific areas that would require that kind of exchange of information prior to commencement of litigation, whether it's some consumer litigation might require a demand letter, employment discrimination, you have to go through the administrative process, and you also, again, have to have a demand letter. And it is through that process parties are able to provide information to each other prior to filing the formal complaint. So, I mean, I think that's a very interesting area. The other area I think I mentioned briefly, and I don't think I need to mention again, is the whole digital and electronic, right? So that the Rules 18 support the use of information and communication technologies, and it's forward-looking in the sense that it says, as appropriate, proceedings may be conducted using any available means of information and communication technology. So in other words, it's not specifying the particular electronic, but rather it's using a much broader category so that it could be implemented even as technology changes. But the third thing that I really liked was the focus on access to justice, I think, so that you have a guarantee of translators. And of course, that would make sense given the European Union, the different languages spoken by the nation states. But on the other hand, the US is an immigrant population. We have a lot of people requiring translation. And again, I think that it's not, and federal courts have individually implemented, programs, and I believe there is a federal statute that also makes sure that the federal court have a translation system set up. but again, it's not written in the rules as a guarantee. And so I thought that really pays attention to the disempower by having that in the rules. And it also, surprisingly, it provides for third-party funding. That is the rules that it recognizes the availability and recognizes third-party funding. Of course, in the U.S., you have the contingency fee, but still, I think you have certain cases where third-party funding is necessary. And here, this rule has recognition of third-party funding, enabling plaintiffs to bring in, but with the requirement of disclosure. And again, in the U.S., the ABA has approved a new set of best practices for litigation funding arrangements. And that was just enacted in August 2020. But again, it's more of a professional ethic as to who controls the litigation, as opposed to a recognition that it could be really an access to justice mentality. And so those areas I really appreciate, and of course proportionality. But okay, here are the two questions, and I love to hear Professor Stürner's kind of comment on it. So when I was reading, and this is so civil procedure of me, it's a voluntary joinder. So the rules in the European rules provide that voluntary intervention can be made by anyone who has a legitimate interest in one or more parties seceding in the proceedings. And that seems very vast, that is a legitimate interest. I know that in the US, the permissive intervention rule is if someone has a claim or defense that shares with the main action, right? And so here, I'm not quite sure what legitimate interest means, and I would like to hear. And then the other thing I noticed was in the collective redress. All around the world, of course, there's a recognition for mass harms and how collective redress is important to appropriately deal with mass harms. And I know that the European rules have opted for an opt-in action as opposed to an opt-out provision. And that's good too, that's fine. The only thing I question is that there isn't something like a mandatory class action, which we do have in US for certain circumstances where injunctive relief is provided, right? And so then the question I have is, if you don't have a mandatory class action, it's all opt-in, and then you have these injunctive relief that's being issued, then I'm wondering if you might, with this rule, open the system to more challenges to the relief that actually collective action ultimately serves. And then again, it probably really gets down to what role these actions serve. Is it structural to change social conduct, or is so that injunctive relief is important, or is it for damages, much more for reimbursement, like in consumer claims, in which case then having no mandatory class action is perfectly fine. And then I guess the final thing is, just because I was trained in the common law tradition, I would not want discovery to be limited to access to evidence. I would want access to relevant information, only because because sometimes you really could have relevant information leading to evidence, but the evidence limits the availability of parties to get information. So those would be the three kind of questions I like to kind of like clarification, which is the voluntary joinder, the permissive intervention on the no mandatory class action, and access to evidence as opposed to information.
Different questions.
Yeah, they are all different. But that's why you're there.
and difficult questions. Yeah. First, the voluntary joinder. It's a very general rule. You are right. Yeah. But the comments try to make it clear that especially cases should be affected by this rule, where a party to litigation thinks to have its own claims against the third party, depending on the outcome of the proceedings.
Okay.
So, and therefore parties could join these proceedings. The problem was that joinder in European civil procedure is very manifold. There are many differing national rules, and therefore the solution was to be a bit more general than it could have been done. I can't say more.
Yeah.
The comments are relatively short, and I remember in the right way. But I found personally that civil codes in Europe, the civil procedure codes, who are very detailed, in the end fail their purpose, because there are always cases which are not met by these more detailed rules, and in the end the courts have to develop case law to fill also to have these cases decided according to these detailed rules in an analogous way. So I'm ready to defend this general rule which was formulated in the end. Now, the other opt-in and opt-out and mandatory class actions. You were right to think that this regulation on injunctions, may be able to replace mandatory class actions. The idea of this mandatory injunction is that an association, especially, could consumer association, for example, could apply for an injunction, for example, not to use unfair terms. And the consequence will be that other parties could take this decision and as binding for the follow-up proceedings. This is not a form of res judicata, because the parties are different, but it's a form of a binding decision for follow-up cases among other parties. So the effect may be similar to a mandatory class action, but only injunctions not to do something are the subject of this form of class action or collective action.
But could parties then challenge the injunction? I mean, in other words, so I'm not. Well, yeah. I'm not a member of the consumer group, or I'm.
Yeah, you raise a question of joinder, of interested other parties,
Yes. Okay. Yeah, that's good.
That would be then if this would be permitted, it would be more and more an approximation to a mandatory class action. Yeah.
Yes.
Good. Well,
perhaps you are much better informed than I, Fernando. What do you think?
Yeah.
No, I was just saying there's a colleague from Argentina, Professor Giannini, who's agreeing with you, Professor Stürner, in the chat. And he says, reading the European model rules, it seems that the collective injunctive relief attend the kind of cases that Margaret mentions, with joint or indivisible relief as the main claim. Class actions for damages instead are covered in the European rules as collective proceedings for the recovery of damages. Relief. I think you are both, I mean, saying the same things. Maybe we should move on a little bit.
No, and the last more critical question was access to relevant information or evidence. Yeah. What does mean relevant? It is true that in American procedural culture, the term relevant is construed much broader than in Europe. But it was the intention of the authors of the law of evidence not to be too broad regarding discovery obligations of the opponent. It is interesting that originally it was an English colleague who drafted his rules, and even his English colleagues seem not to be very happy about too broad discovery. And therefore, there are special requirements, forms of a prima facie case, for example, which is a form of plausibility, that there could be a case, and this is more than the Americans would find correct and helpful. They still like the much broader form of discovery. It's a compromise.
Yes, if I may, Margaret, you find it too narrow. Many readers in Europe would find it too broad.
Too broad. So there you go.
That's right. So
and also depends on if you're more pro-plaintiff or pro-defendant.
Depends on the ecosystem where the rule is to be applied. Do you think the rules
for European circumstances, this is a big step towards more discussion? Not for Americans, but for Europeans, it's a big step towards more discussion. It's a bit more limited than in England, to take care of continental traditions.
Wolf, I know you are not in the possession of a crystal ball to see the future, but I would even dare to ask you if you think the rules are going to play a significant role in practice. I'm thinking more precisely maybe in two possible ways: directly on European states, which could use them as a source of inspiration for domestic reform, but also indirectly, again, on European Union member states, if the European Union would take in serious the idea of setting common minimum standards of civil procedure. And in that case, if it could use the rules as an inspiration.
Let me begin with a more general remark. During the last 15 years after the affirmation of the ALI UNITRA principles, as one of the reporters of the project, I have been often asked, what about their success? Could you give examples making their influence visible? Regularly, projects on international harmonization of national laws are subject to very critical observation, especially by people who did not take part or were not asked to take part in their development. This skepticism exists not without good reason. The road to model law, the road of model law, to influence on case law and legislation is long and burdensome, and sometimes it is hard to differentiate between prognostic strengths of model law and real evidence-based direct or indirect influence. However, to make 3 examples of the short history of ALI and the DRA principles, they turn back to fact pleading in American federal civil procedure as intended by the US Supreme Court, happened only 3 years after the affirmation of the principles and 1 year after their late official publication. And the European legislation on evidence taking in cases of compensation of damages caused by cartel conspiracies refer to the principles in a hidden form within the White Book, preparing the relevant European directive, but only in the White Book says the materials to prepare legislation. A clear form of reception of the principles can be found in the draft of the procedural rules of the Unified Patent Court that overtakes not only the procedural structure, but also the unique terminology interim phase for the flexible middle part of the proceedings, a term created by the lucid co-reporter and ingenious promoter of the project, Geoffrey Hazard. The structure of proceedings of the increasing number of special courts for international commercial disputes within Europe shows a lot of similarity with the structure developed by the ALI unit DRA principles and now of the European model rules. And only sometimes drafters of such rules may give a hint that they took the principles, the already existing principles, as a helpful example. The proceedings of these special courts for international commercial disputes may have in part have their own procedural regimes, or they may use their national codes using remaining leeway for adaptation to the necessities of foreign parties and to internationally acceptable standards of proceedings. There is good hope that first these courts or arbitral tribunals, international arbitral tribunals, may take notice of the European rules and their much more detailed proposal of implementation, putting emphasis on flexibility appropriate for use, especially in cases of disputes between parties from different legal cultures. The development towards courts of international commercial disputes with some openness for advantages of foreign foreign procedural transplants with some openness for such transplants may also influence national legislation openly to have been under foreign it will influence national legislation, and it's true that national legislators very rarely openly confess that foreign law or model law was decisive for their considerations. Mm-hmm. For instance, the German turn from very restrictive obligations of the parties to produce documents and other means of evidence in the interest of their opponent to an internationally accepted level, and its implementation by the Federal Supreme Court has been the result of harmonization within Europe, so never really mentioned and really conceded by the legislator. National and European legislation seeking orientation without any doubt may have a look on the new model rules as a possible model. However, drafter of model rules should take into account that they function as ends within the worldwide development of law and not as heroes in lawmaking. And that the road to better law is long and burdensome, already a contribution to harmonized and not really unified law should be seen as a success, especially against the background of democratic lawmaking that to a certain degree tolerates variety as a result of regional self-determination in a time of increasing very large economic areas. We should see that there is a tension between the democratic legislation. Democracy is regularly having a regional character, and uniform law in large economic areas. So my answer may not be satisfying, but I think we should be modest, and not wait for too much visible success that people say that's it. This will not be the case.
Of course, one have to. It's important in life, in every domain of life, to manage expectancies, and also here. Margaret, in the US, you are accustomed to having the federal rules of civil procedure, which also serve in a way as a model for state procedural legislation. Any similarities in the role these European rules could play regarding national procedural law in Europe?
Yeah, no, it's really an interesting question. And I totally agree with Stürner that says that the influence is going to be much more informal. People are, both because of national origin, legal origin, school thinking, as well as nationalism will probably prevent nations to openly adopt these rules or recognize it openly. But I do want to kind of mention that Scott Dawson, who actually I thought was online, but I don't know if he's online anymore, but he wrote a terrific piece called Looking at the Gravitational Pull of the Federal Rules. And that is that despite the fact that still 13 states in the United States are not, in their state procedural rules, are not following the federal rules. But there is the Supreme Court cases, both in the pleadings, he looked at pleadings, he looked in summary judgment. It does have an effect. It's the gravitational pull, and it may very well be that it's much more cost effective to be able to look at something that has been carefully drafted and nicely and elegantly drafted, and to follow that, so that the work is done already. So you will have some gravitational pull. But I actually think it's more important to really think less of whether these model rules will top-down be adopted, and more to think of it as a reciprocal process. Because it really is, at least in China, some of the most innovative civil procedure rules were started in the localities as a matter of experimentation, in recognizing local conditions and to start small, experiment small, and then to bring it up. And so I would think that, these model rules really should be considered part of a process, and that it's really a recognition that it's going to periodically come back to recognize local experimentations, and then and to make adjustments. And so just 2 points then really is that, yes, there will be gravitational effects of the federal rules, of the European rules, and it will hit against nationalism, and it will hit against legal origin, historical inertia. But the gravitational pull, just because of the efficiency, is there. But ultimately, we should be happy that there is local experimentation and that there are local variations.
I fully agree. Harmonization is not at odds with identity and tradition, and vision of national vision of proceedings. But let's move from regional into global. And I will get back to Rolf for a last round of questions before we give some space to our guests. Do you think the rules would contribute to the global debate on making procedural systems more understandable to each other? Have the authors strived to bridge possible gaps between different legal procedural traditions? Would be another way to put the same question.
This question addresses in part topics already addressed.
Yes.
Similarly, by the preceding question. However, without any doubt, it puts also emphasis on prerequisites of reception of model law if we leave areas of already strong coherence and turn to areas that are much more different than Europe and the individual European states. Worldwide, there are legal cultures with an already long own continuous tradition without revolutionary breaks or economic and social catastrophes. Other legal cultures are still developing or are still affected by revolutionary phases and quick economic changes, being in steady or repeating search of better economic, social or legal models. These legal cultures, like some Ibero-American or Asian and especially African states, may be more open for the reception of foreign law and foreign legal models to improve their present situation that states like the US or Canada that may trust more in the experiences of their own successful history and make only very rarely steps towards foreign transplants, and this in very special cases only and to a rather limited degree. Some observations of the Japanese and Chinese or Brazilian development during the last decades in some fields of their laws permit some very cautious remarks only from my side. Japan has developed a relatively independent own conception of civil procedure after phases of mainly German and French and later American influence. Today, reforms are considered on the basis of domestic experience and still on the basis of comparative consideration. It is interesting to see that individual national laws are of continuing interest. However, more and more also model law, for instance, in the field of the law of contracts, are of special interest and regarded as an indicator of the modern European development. Compared with Japan, China is still much more open for foreign influence on the law of civil procedure and civil enforcement. So the example of national European law or Japanese law and American law are still analyzed and taken into consideration. Like in Japan, there is also a strong trend towards taking account of the law of the European Union and European model laws, insofar as European law does not exist. The increasing tolerance of European legislation towards in-court settlements has found a very fertile ground in Japan and China, surely under differing social circumstances. In my point of view, as in other fields of law, the European model rules of civil procedure may have a good chance to find the interest of legislators there, even regarding, for instance, details of the organization of in-court settlements, and this is also true for other parts of the European rules. The reception of US-American civil procedure has to surmount the difficulty that this procedure needs well-working lawyers dominating the party-driven proceedings, whereas the European model of civil procedure is much more dominated by judges, and their formal and material case management harmonizes much better with Chinese traditions than the American model with its still less active judges and dominating lawyers. This constellation may be a matter of concern because it includes also possible abuse by authoritarian judges. At the same time, however, it may demand, for the example, of a carefully balanced common European model as offered by the European rules. In Brazil, with its long traditional connections to European legal culture, rather than to the economically very influential United States, common European model rules may also find much more interest than legislation of individual European states. Finally, it has been always to be taken into account that the worldwide influence of legal culture, and in part that the worldwide influence of legal culture depends also to a high degree on the political stability and economic power, and in part even on military strength of the legal actor. Until now, a clear advantage for the US, so many states prefer sometimes distance to very powerful worldwide actors, an advantage for the competing weaker Europeans. We will see how it works. And we hope for fair competition.
Thank you. And also, yes, kind of overlapping, but as a final question to Margaret, do you consider the rules that they are understandable for common law and Asian lawyers?
Mm-hmm.
Because this would be probably a prerequisite for a more reaching impact.
Yes, but I also thought Professor Stürner's comments were really interesting. It almost is suggesting, and I don't know if he is, that transplantation follows economics. And so that may be the best indicia of whether or not Asian systems will adopt some of these rules. But to my mind, it's definitely true that both China and Japan are civil law countries. And so these rules will be a little more comprehensible and consistent to the Chinese or the Japanese legal system, more so than the adversarial system and the common law rules of the US. But I do think what will ultimately decide what rules will be followed really depends on the role of litigation in the different societies. And in Asian societies, litigation serves a function that is supposed to support state interests as well. It's not, it is only individual disputes, but it is also in the individual disputes, it's supposed to support state interests. So if you have the Chinese rule at Article 2, you're supposed to, the litigation, maintain the social and economic order and safeguarding the smooth process of socialist construction and development. So what that means is that I think that to the extent that the European rules give more authority or more power to party than to judges, there will be resistance. The Chinese rules still provides that courts determine the kind of scope and method of the litigation and requires the courts to investigate. The reality is that it's so expensive and so time-consuming that courts don't do their thing. But nevertheless, the permeate throughout the procedure code is really, I think, more authority to the courts. And in fact, the People's Procurator is in charge of supervising litigation to make sure that state interest is protected. And so, if whatever rules that will be influential on Asia will be the technical aspects, and I actually think the part that Asian countries are grappling with right now are oral testimonies at trials, because so far it's been very documentary based. All the cases are decided in documents, but there is a push to have live witness testimonies. And the US, with the adversary system of objections and complicated hearsay exceptions, would never be an appropriate model. And so I think that in looking at the European rules as to how you all deal with taking live testimony in court would be really, really useful. And finally, the other thing is the mediation. You know, the Chinese, both the Chinese and Japanese have incorporated mediation conciliation as being part of their codes, even before the European. So I think that what they're going to do is want to ask, are you guys going to follow us in terms of mediation and conciliation? I mean, there's a whole big section and several different Chinese statutes dealing with conciliation and mediation. And so I think the question would be turned back as to whether or not, in fact, you're going to follow that way rather than the Chinese and Asia following the Europe.
You may have seen that there is one difference to Japan and China. If judges were mediators using caucusing, they are excluded. Yeah. Because the Europeans take the right to be heard, which is a part of the adversarial system, more seriously than Japanese colleagues. And it is interesting, for example, to go to Japan and to see that the judge negotiates with one party in the absence of the other, and so on. You know it, I think. And this is not permitted.
I know.
So we are a bit different. And more similar to the common law countries.
Yes.
Well, I think we have some time spare to open the floor, and I'm going to make an experiment, and I'm going to let those formulating the questions to make them personally by opening their microphones, but only if they swear to stick to the questions they put in the chat or on the Q&A part of the Zoom. Otherwise, I will have to mute them. So I'm permitting Rick Marcus to speak because he was the first. He posed on the chat one question for Rolf and another for Margaret. I would like to listen to him in person because it's more.
Can you hear me?
Yes, we can. You.
So Rick, to refrain from making a long intervention, just
I will try to summarize what I wrote in the chat. First, a reaction to Rolf Stürner's very instructive presentation. I had the pleasure to work with Astrid Stadler and Emile Joland on the collective action provisions. I thought there was something in there about the judge having discretionary authority to switch to opt out.
There is,
Astrid Stadler took some persuading on that score. My general question for you is, do you think, as it seems to me, that maybe there is some convergence here as the U.S. narrows, defangs the big bad wolf of the U.S. class action? Maybe it's getting more like a European movement, partly, I think, in Germany, spurred by the Deutsche Telekom experience, towards more collective proceedings. So are we moving towards each other? That's the question there. Margaret, with regard to proportionality, I think Neil Andrews described the Wolf reforms as Lord Wolf's bulldozers running through English procedure and making proportionality a central feature in the UK. And what crosses my mind as a question is, it would seem that's related to whether there's a loser pays system. Now, we don't have that. Japan does not have that. Most of the continent, I think, does. And I wonder if having a loser pays system, whatever else can be said about it, might tend towards proportionality, at least in terms of litigation expense.
Well, thanks so much, Rick, for your questions. First, Professor Stürner, then Margaret, because that was the order you put the questions.
Yes, Rick, I think it is a result not only of the Deutsche Bank case, it's a result of the lacking of the lacking activity of the European and national legislators and administrations in the diesel cases, yes, and before in the bank crisis, in the financial crisis, yeah, because Europeans are accustomed that legislation and administration protects citizens from this mass harms by legislative and administrative preventative measures. And this didn't function. And this is the reason why there is a stronger trend in Europe and Germany to have forms of collective redress. Yeah? Whether this will really work in these cultures is not. We will see. Yeah. It could be that we need a more adversarial society, perhaps. Yeah. A competing society. Yeah. To have really a real success regarding collective redress.
So that is an interesting question about whether loser pays is the rationale for proportionality. I guess my only thought is that even in the federal rules, when you ask for, even within the federal rules, you could ask for costs, and there is a reasonableness requirement there, right? So it's already in the rules for the cost assessment. But what is most significant for the proportionalities is just interweaved throughout. So I actually think it's really more a systemic concern rather than a cost concern, rather than an economic kind of can the parties recover their costs concern. But it could be both as well too. But it's a really interesting question.
Well, now let's move to the next question made by Christian Delgado. I don't know if you're there to formulate it in person. I just activated your microphone. Are you there, Christian? Otherwise, I shall just directly read your question. He seems to be muted. And he might not just be active. Well, he was just asking, how does cooperation in civil procedure or European model rules deal with contractualization in civil procedure? Is there any regulation allowing parties to celebrate this kind of modifications within the procedure? I guess maybe Professor Stürner would like to answer to that question.
Yes, parties can agree on many details regarding civil procedure. We should perhaps have a look at the rule 20, I think it's 26, already cited by Margaret. Yes. Rule 26 says, where parties are free to dispose of their rights, they may agree on the legal basis of the claim and on specific issues in the claim. Such an agreement must be explicit and must, even if it was made before commencement of proceedings, be set out in the pleadings. The agreement binds the court. And there is another, our other rules on the joint application of parties. The parties could apply jointly to the court, and this joint application of the parties to decide only issues chosen by the parties and not decide the whole case is also binding for the court. Rules 57 and following. So there is a lot of influence of parties, or take the other rule on court management orders. It's Rule 50. If the parties agree on a case management measure, the court shall not determine differently without good reason. So the possibility of parties to agree on the course of proceedings is taken very seriously. For some European cultures, there's even too much party influence. This is a more innovative step done upon French and English influence. So it's a joint application. Is a French French innovation of the last 2 decades, and the English techniques of pre-commencement protocols, which regulates the exchange of evidence and so on, is now nearly 10, 15, no, 20 years old.
Thanks, Professor Stürner. I think we still have a few minutes, and I just permitted, I think he's aware of it, Professor James McSigner to quickly reformulate a couple of questions he wrote in the chat. James, the floor is yours.
Can you hear me?
Yes.
Oh, okay. Well, a lot of things have occurred to me here, but in respect to the question, just responding to one of the questions we talked about a moment ago, to the costs, whether it's loser pays and all of that, I think the biggest difference there is the role of the judge versus the role of the lawyers in determining how much discovery or time is taken. And I think that's the basic. I think that's the basic message. The American system is so far away from having judges help find out what the facts of the case are and what's the truth is. The American system is just totally mired in the adversary's system of lawyer control.
One personality,
It's just astonishing. A few years ago at a conference, we were talking about cooperation in the federal rules just on discovery. And I wanted to say, and they wouldn't let me say this in the conference, is I really think 138, 139 and CPO, the general role of the judge in bringing the case along to find applying laws to facts is what makes the German system work. My question, Professor Stürner, is to what extent are the European rules mirroring the German rules on cooperation, or are they, or how are they different?
I think we should not speak of German influence. It is true that the active judge is a development on German soil, beginning with the first decades of the 19th century. And this idea found more and more the consent of other European countries. For example, the French code says always, le juge peut inviter les parties. That's a bit more reluctant because le juge peut, and they say not le juge doit inviter. That's the difference. But in the end, the strong movement towards more active judges in our working groups, and that was really surprising for me, did not come from Germans. The Germans were in the end a bit more reluctant than these enthusiastic people speaking of cooperation. It's a new, some European legal cultures discovered this possibility as a new instrument, yes, and they are more enthusiastic than Germans are in part. Regarding the history of the active judge, it is true that it's a German and Austrian legal culture, Swiss legal culture, which developed this model. But now there is a relatively broad European consent. And even in England, there are takes a commercial court in England, yes, very active judges, yeah. And the same is true for other commercial courts in Europe. That's a modern, much broader trend in Europe. So it's not. It's never good to say an idea comes from Germany. That's not so good.
Carl Llewellyn said it was to give it the kiss of death.
Maybe according to one of the drafters of the Uniform Commercial Code, Llewellyn, it may be the kiss of death for a good idea.
That's what he
comes from Germany. In common law countries.
But the Chinese too, you can't say it's coming from China.
And it hasn't changed in the United States in 75 years.
You are right.
Thanks.
You've got your law, we've got ours, said Scalia.
And thanks, Rolf. A more concise and direct question to Margaret, maybe a little out of the scope of the webinar, but just maybe a short answer would be good, from Professor Alena Makova from Prague, Czech Republic. What is the recent experience with class action in consumer protection in the USA, and more concretely, has it been replaced by ADR remedies or not?
Wow. So I'm a little. So let me just rephrase the question so I can understand it. So what is the status of class actions for consumer cases, and has it been replaced with ADR? Is that what?
That should be.
Yeah.
I know it's a little out of the scope of the webinar, so maybe a short answer.
No, yes, a short. It's fine. I mean, this
among yourselves in a future moment.
Yeah, it's interesting. It's less the ADR, I would think, and I would love to hear Rick's thoughts too. It's more legislation by the U.S. that discourages these massive and procedural rules that end up making some of these major class actions more difficult, like the Walgreen case coming out and so on. So that class actions now are more successful if they're state-based. They're more receptive. The ADR question is really, really interesting, and I will only say it's not ADR as much as the electronic ADR. In other words, it's so often you would go on, you make a purchase, and you've already agreed to ADR without knowing it. And so that is the latest, I think, flood of litigation as to when that kind of agreement constitutes consent for ADR.
Interesting.
Yeah.
And then I would just allow a last question, because we're just a little far away from our initial schedule, from Leandro Giannini, Argentina. I don't know if he's there. I'm just going to let him formulate a question on appeals, a very direct one. Leandro, are you there?
Yes, I'm here. Can you hear me?
Yes.
Yes.
The question is regarding to appeals. I read the initial comments on Part 9 of the European rules, and they explain generally that the rules conceive first appeals, the ordinary first appeal, as a conditioned right, meaning that parties have right to appeal the final judgment, but have to seek permission based on a kind of real prospect of success test of or similar criteria. However, when I read Article 166, they determine a criteria that it's more generally oriented in the general importance or general significance criteria to grant that permission. So the question is, could it be that the case that the general intention of the drafters to allow appeals based on the entity of the error or a real prospect of success test is not sufficiently incorporated in the rules?
I think we should read Rule 166 perhaps a bit differently. If the value has reaches a special amount, yeah, appeal is in principle admissible, yeah.
Okay.
And if the value necessary is not reached, the appeal is admissible if the appeal court grants permission to appeal. And then there are rules when it is necessary to grant appeal, yeah, to permit and to leave appeal, yeah. So there is no general requirement of admission to appeal, but the appeal is limited because you are in principle not allowed to base the appeal, the first appeal, on facts or evidence which should have been pleaded by the parties already in first instance. Yeah. But we should see that the court's duty to give hints and feedback, yeah, enables parties to base appeal on defective application of procedural law by the court, yeah, because the court did itself not give a hint that the parties should, for example, offer better evidence or should introduce new relevant facts to justify their claim. Yeah. But it is true that on the continent there is a strong tendency towards limiting even first appeal to control of mistakes and deficits of the first instance proceedings. Only France is very generous, still very generous, and allows new facts and new evidence, yeah, without really limitations. But in all the other civil procedure codes, there's a trend towards limitation.
Good. Well, I promise the last one, but I think there's a student who has attended all the whole webinar, and he dares making a question. So I think we should end the webinar with a student, which shows that the new generations are interested in our topics. So Martín Freite Sandoval from Chile has a very specific question also to make.
Hi. First of all, thank you for accepting students in this webinar. This is a great experience for a lot of young people who are interested in the procedural law. Now, my question is actually a little specific because here in my country, I am a student from Pontificia Universidad Católica de Valparaíso here in Chile. And in my country, we are preparing the new code of civil procedure rules. And something I talked with my teachers is what do we do with this new code? And now that we are talking about these European procedure rules, I ask to you your opinion. Should we just take them? Should we grab some inspiration from the European procedural rules? Should we avoid them? What should we do? Because even one of my professors, Raúl Núñez Ojeda, he reminds us constantly, our code is archaic, trash. We should only take the CPR from England and just copy it. So I wanted to ask you, what should we do? What's your opinion about it?
Well, a quick reaction from Rolf and Margaret, and then we would take a farewell.
You see, it may be that the society of your country will not be happy with the English code, because the role of the lawyers was different over centuries, yeah? And it would be a hard break in the end to do this. There is a more continental orientation in your tradition, but I would also not say take the model rules as such. They must be adapted to the necessities of your special social situation. Yeah. So a clear, pure transplant is not really recommendable. Yeah.
Mm-hmm. I totally agree with Professor Stürner on that. I mean, this is a big question you just asked. In other words, you're asking the validity of legal transplantation, and I think that it has often been challenged, right? That you can't just take the words and put it into another country and ignore the country's own historical trajectory. And so adaptation definitely is what's needed. But again, it's very efficient to already have wonderful scholars who've already drafted and given it some thought and have drafted some best practices. So it should certainly be studied and adapted. Yes.
Good. Well, I think that's all for now. It took a little longer than expected, but I think it was worth listening to Rolf, to Margaret. Many thanks. You've given us very, very interesting ideas. I think everybody has learned a lot from the webinar, and well, I'm just promising that there will follow others on other interesting topics with, let's hope, as good speakers as we had today. And well, in the name of the International Association of Procedural Law, I just wanted to thank again Professor Stürner and Professor Wu for their generosity. They gave us freely in the most generous way their time, their efforts, and we must be thankful for that. And let's hope for future face-to-face meetings in the future. And to all who are attending the webinars, please keep faithful to the association, keep faithful to the webinars we're going to organize in the future. And of course, it will be great to be meeting in person as soon as the pandemic, vaccination, and so on will allow it. Kind farewell to all of us. Thanks. See you soon. Goodbye, my friends.
Thank you.
Thank you.